Oh, you have come.
I have come, but there is a slight technical problem. But I am sorry for the inconvenience. But this item number one,
Yes.
it perhaps may not be technically correct for me to appear today. Let it come up on 24th of June. I've spoken to my learned friends.
Let's 24, I have a fixed method. Maybe on 25. Let's see. I mean, even if it is fixed tomorrow, I have no
No, no,
problem.
what is your problem today?
But actually, technically, because of the dissolution of the assembly, there is required to be an order allowing me to continue till the next cabinet takes a decision.
Oh,
So
such.
that order is yet to be issued. I have been informed that it is in the process, but today it perhaps may not be proper for me to appear as an applicant. And in any case, a rejoinder also has been filed. So I am getting a copy.
Yes, Lordship, last time, the rejoinder has been filed.
Reason.
24th.
10%, 25%.
25 is our.
Sir, 26.
24th further program. That is validity on 21st. 31st.
20%.
On the last few occasions, actually, I had come prepared. My learned friend had some inconvenience.
Oh. Heard, Mr. Yeah. You're Mr. G card to the Learning Council for the petition. And it is seen from the office report that the rejoinder affidavit has already been filed by the petitioner side. It is submitted by Mr. I. Chaudhary, the learned Advocate General Arunachal Pradesh, assisted by Ms. MS. Assisted by you are assisting today?
No.
Assisted by Mr. S. Tapin, the learned senior advocate. It is submitted by Mr. Chaudhary, the Advocate General, that due to some technical problem, he is not going to appear in this case today for further proceeding, for further hearing of this case. As what is the main issue? In fact, you are not.
Your Lordship may
Technical.
record that there is some
Technical.
problem. Or your Lordship may even record the reason of rejoinder being filed recently.
The rejoinder has already been filed.
No,
It has already been filed.
Yes. Have you received the copy?
I have not. I had not received the copy,
Okay.
but it has been served on the government.
Technical very. It's not
Last time,
intention
Lordship,
to appear
rejoinder
before
was
they have to go for the hearing today. And considering the same, the matter be adjourned. Yes. Last.
Yeah, rejoinder was last filed last time, Lordship.
Yes, you have filed.
It's been
You have
13
filed
days. Yes, Lordship.
Copy has already been filed.
Already.
So copy has been served on.
Copy has already been served to the petitioner, the respondent side, state respondent side. Let the matter be listed on 25th or 24th?
21st.
21st. Do you have any objection? 21st?
No, Lordship. Even if it is fixed tomorrow, I am ready, Lordship.
Definitely, but he has some technical problem otherwise. Okay, then 21st.
Okay.
May I, Your Lordship?
Yes,
Lordship, I beg to mention item number 13, Your Lordship. This,
1-3.
yes, sir. This matter may be listed after 4 weeks.
Who?
Aye.
Yes. Oh, yes, it's why? Just ask them, ask them. In item number 13, you are for?
I'm for the state, Your Lordship. We are going to
sorry.
file our counter affidavit.
You have filed your counter affidavit only.
No, Your Lordship. We
Not
have not
yet.
received the instructions, sir. Lordship
Okay.
mentioning.
The petitioner side is, have you informed your side?
Yes, Your Lordship. You have taken concern, Your Lordship.
Item number 13. You are on the item number 13. Heard Mr. Swenson, the learning council appearing on behalf of the petitioner, and also heard MS, yes, MS Swenson, government advocate. It is submitted that she needs some more time to file their affidavit in opposition.
1-3.
Prayer allowed, let the matter be listed. And we want 2 weeks or
4 weeks, Your Lordship.
4 weeks?
Yes, Your Lordship.
List a matter after 4 weeks, enabling the respondent to file their affidavit in opposition.
1-3. Your Lordship. And also,
Yes,
Your Lordship, item number 25 and 26, Your Lordship. I'm mentioning on behalf of AAG Arish Nabam, Your Lordship. This matter may be listed after 2 weeks, Your Lordship.
Your Honor,
you are appearing on behalf of DSGI,
Yes, Your Lordship. No, state government, Your Lordship.
state government,
I'm appearing on behalf of petitioner, Your Honor.
on behalf of,
No, I'm appearing for petitioner, Your Honor.
you're for
I'm for petitioner.
petitioner. You're
Yes, sir.
appearing on behalf of C Modi,
No, Pathak, P. Pathak, sir.
B Pathak.
Yes. Your Honor, this matter may be fixed on 25 as the council is from Guwahati, Your Honor.
B Pathak is from Guwahati, na?
Yes.
Why you need an adjournment, why?
Hey, Your Lordship, AAG Arish Nabam is appearing, who is not present today, Your Lordship. So instructed me to adjourn this matter.
Because.
Yes.
Heard MS so and so appearing on behalf of Mr. B Pathak, AK Hoko, and also heard MS so and so, the Honorable Government Advocate, and it's sought for an adjournment stating that the additional government advocate general is going to appear in this case. In the meantime, the petitioner, the council for appearing on behalf of Mr. B Pathak for the petitioner also prayed for an adjournment, stating that the NK's council is from Guwahati and he is not in a position to attend the court today. Considering this submission made by the council for both sides, let the matter be listed. You're supposing you're telling, what is your convenient date?
Pardon yourself.
Your convenient date is when?
25, Your Honor.
25th of
This month.
this month?
Yes.
Okay, what is the list of both the matters on 25? Can you keep 25 key? 6, sorry. 25/6. 25/6, okay.
God bless you.
My lord, I'd like to mention at number 17 to 20, my lord. Here, I have not yet received Parav's comment. I require to file affidavit, my lord. I've taken consent from the other party also, petitioner, my lord. This matter will be taken after 3 weeks, my lord. In the meantime, I'll file the
In
affidavit.
all the matters. 17,
Yes, all the
18,
matter. It's
19,
all similar matter, my lord. Similar matter. 17 to 20, my lord.
With the consent, you are for the petitioner, no? With the consent of the other side? The learned standing council education submitted that he has not received the Parav's comment from the department to file their affidavit in opposition and needs some more time to prepare the same. List accordingly, and when you
After 3 weeks, my lord.
2 weeks.
Three
After
weeks, 3 weeks, my lord.
List accordingly after 3 weeks. Would you get accurate order?
And my lord, so I'll beg to mention item number 15, my lord. Here, my lord, I'm on behalf of C. Mantau, my lord. He's a council outside, my lord. He requested me to make mention, my lord. May fix this
He
matter
comes from where?
from Namsai, my lord. Namsai district. And he requested me to fix this matter on 4th July, my lord. I've taken consent from the other side also. 4th July.
4th July.
Yes.
With the consent of the other
4th July.
side, the learned council list. Your name কি আছে?
After. Okay.
T. Takum paid for an adjournment stating that
My lord.
the NK's council, Mr. C.W. Mantau. 4th July is vacant.
Yes, my lord.
C. Mantau, that is not in a position to attend the court today.
15 it will be done.
List the matter accordingly on
15.
15.
15.
15th of July.
Yeah, that is thereafter, my lord, immediately after vacation.
Oh, it will be immediately after. Up to 14th, we are having holiday. 14th is Sunday.
15 or 16, my lord.
15th, okay.
Yes.
15th of July.
And my lord, there's an interim order, my lord, that may be continued, my lord.
Interim order be continued till next date of listing.
Deeply obliged.
Lordship, I beg to mention item number 24. I am for the petitioner as the leading counsel could not come today due to health issue, Lordship. The matter may be listed after 2 weeks, Lordship.
You're for the petitioner.
Yes.
Oh, Mr. R. Sakya.
B type, Lordship. As a leading counsel is R. Saikya.
Ah.
So his health is not good, Lordship. I have taken the concern from the other side.
Okay, order for you. Why you need adjournment? He is out of station or what?
No, due to health issues, Lordship.
Due to health issues?
Yes.
So what will be, after 3 weeks we'll do?
Lordship.
List after 3 weeks.
Oblige.
Yes.
Your Lordship, I beg to mention item number 9. I'm appearing for the petitioner and on behalf of Duyu Laji.
Huh?
For the petitioner and on behalf of the leading counsel Duyu Laji.
Ah,
Due to some personal difficulties, he cannot attend the court today.
he is present in the court or he is not absent?
He's not.
Due to some personal difficulty, the learned and this counsel, Mr. D. Laji, is not in a position to attend the court, and on his behalf, the adjournment is prayed for with the consent of the other side. List accordingly after 2 weeks. As amended 2 weeks by the registrar.
Your Lordship, I beg to mention item number 11 and 12 on behalf of Deep Pangin. He is out of station.
The Panging is not present today.
Yes. Later
Have
may
you
be
taken
list-
the consent of the other side? Government advocate was there, I think, na? Both 11 and 12.
Yes.
The Panging I will order for you.
Matter may be listed after 2 weeks.
List after 2 weeks. Okay.
My please, Lordship. Lordship, I beg to mention item number 14.
Item number?
14. On behalf of D. Kamduk, we are supposed to file affidavit in opposition. So somewhat
Here,
maybe
the Panging is in item number 14.
1-4, my lord.
Here also, the Panging is appearing for? Acha, for the
My lord,
petition.
at number 14, my lord. I'm petitioner, my lord. Yeah,
You are for the petitioner.
my lord.
I am for respondent number 2 and 3
Respond number 2 and 3.
on behalf of D. Kamduk, the Standing Council of Land Management.
Standing Council Land Management. Appearing on behalf of Hard Mr. T. Tabung, the learned counsel for the petition. And the learned counsel appearing on behalf of the Standing Council Lands Management, Mr. D. Pangin, paid for an adjournment, stating that due to personal inconvenience, he is not in a position to attend the court. Please, accordingly, you need any time?
My lord, after
Uh,
3 weeks.
3
it's,
weeks.
My lord, there's an interim order, my lord. Interim order will continue.
3 weeks. Interim order will continue till next date of listing.
Deeply.
May I Lord, I would like to mention item number 16. I am on behalf of respondents. I have taken consent from the petitioner. So here I have yet to file my affidavits.
Yeah, the government advocates, government advocate is also there
Now I am for
for the private respondent.
the standing council RWD.
Oh, acha, acha. Standing council.
Yes.
RWD, acha. You are Mr.
G. Tarak.
G. Tarak. Tarak, there is an standing council for RWD, paid for an adjournment with the consent of the other side. Why you need adjournment?
So I have yet to file affidavit in opposition.
It is stating that he could not prepare the affidavit in opposition and hence needs some more time. Prayer allowed. List the matter, you 1 week or 2 weeks?
2 weeks.
List the matter after 2 weeks, enabling this standing council for RWD to file their affidavit in opposition. List after 2 weeks. Okay.
Obvious.
May I please, Your Honor? And I beg to mention Civil Revision Petition 10 of 2024, which was last listed on 6/5/2024 to be listed on 7th, Your Honor, this Friday.
This Friday, in which column?
In this
Admission?
court.
Admission column or order column, what column?
Last time it was partly argued, Your Honor, for final hearing.
Partly argued,
Yes, Your Honor.
partly argued before whom?
Justice Guri Habum.
No, partly argued before whom?
Justice Budi Habung.
Budi Habung. Then you do one thing, Mr. Habung is coming most probably since 18th or 17th, he is having his bench. So let it be listed on 18th or 17th or 18th, if it is only partly argued.
No, but Your Honor, I believe it has to be argued from the beginning because only the side of the petitioners were heard and that too only half of it.
Seventh,
counsel will be coming
seventh may
from-
not be possible. I have two meetings in seventh. Let it be on seventh. If it is not possible, then make it on 10th or 11th. Is the hearing better?
Yes,
11th
Your
will
Honor.
be possible for you, 11th June?
No, the thing is that the counsel for the petitioner, he'll be coming from Guwahati.
7 may not be possible. 7 actually, I have two meetings, so it may not be possible. If you can inform him, then it can be taken up, on Monday by 10th or by 11th.
Okay. Your Honor.
11th June, it is a hearing day also.
Okay, Your Honor.
11th
Your Honor,
June is
I will call him and then I
okay,
will
then
give
for
the
your
number.
meeting, you
I
just
will give
ask.
the dates.
Okay.
Obliged.
Just take permission.
Yeah, madam. Hello, this is not a new read petition. In terms of order dated 29/5/2024, this has been listed under motion column.
No, yes, but I have seen the office note. You have not filed the amended portion.
I was allowed to correct with hand, that I have done in the synopsis.
In synopsis.
Yes. That I have done yesterday.
Oh, acha, it is already corrected.
Otherwise, my lord,
Ah.
the state respondents have filed their affidavit.
Hmm.
And in reply, I have also filed my affidavits, my lord.
So let the matter be listed in admission
But,
column.
no, this is a covered matter. This can be disposed of matter. I will hardly take 5 minutes. If he's.
Okay.
My lord, the facts and the legal provisions in brief are as follows. There are two executive orders whereunder it is mandatory for obtaining no objection certificate from the concerned deputy commissioner for finalization of pension and service benefits. That orders, my lord, will find at page number 29, first order.
29.
29. This is by the Directorate of Audit and Pension. Typed copy 20. May I read? Subject NOC from concerned deputy commissioner for settling retirement dues. Government of Arunachal Pradesh, by order number such and such, decided that for vigilance clearance to government officials for promotion and for settling retirement dues, NOC should be obtained from the concerned deputy commissioner, clearly stating that the government official has not encroached upon any government property nor has caused any damage or abated encroachment on the public property by a private person. Henceforth, all the heads of offices shall invariably obtain NOC from the concerned deputy commissioner in respect of each official proceeding on retirement. This shall form part of pension documents in addition to documents stock forms prescribed under CCS Pension Rule 1972 to be submitted to the Director of Audit and Pension, Government of Arunachal Pradesh for settlement of pension and other retirement benefits. Second order, my lord, will find at page number 31. Page number 3 was not, has my lord. Third paragraph. To curb this practice of encroachment and demolition, illegal use of public property, it has been decided that vigilance clearance to government officials for promotion and for settling retirement due NOC shall be obtained from the concerned deputy commissioner, clearly stating that the government official has not encroached upon any government property nor has caused any damage or abated encroachment on public property by a private person. Number, the petitioner's husband, who was serving as assistant engineer in Public Works Department, died in harness on 25th of April 2021. Thereafter, petitioner submitted the required documents for availing pensionary and other service benefits which became due on her before the executive engineer Bomdila. Now, the executive engineer Bomdila in turn, by communication dated 5/7/2021, requested the deputy commissioner to issue the required NOC. That communication, my lord, you find it page number 24. Page number 24. May I read? To the
Yes.
Deputy Commissioner, West Cameng District, Bombila, subject issue of no objection certificate for pension. Sir, please issue no objection certificate in respect of late Pema Dorji Tungat, who expired on 25/4/2021. The same is required by Director of Audit and Pension, Nahalagan White Order number such and such for finalization of family pension. This is for your kind information to take necessary action, please. This is it. As on date, my lord, there is no proceeding pending against the petitioner for encroachment of government land. But
They were possessing the common quarter, in fact.
no, nothing, my lord. In
Then
fact,
why this allegation is brought against them, regarding the
I,
personal
my lord,
property?
I constructed a RCC building over government land, which was not allotted to me by communication dated 28/6/2023. The Directorate of Land Management has conveyed approval of the government for regularization of that allotment, my lord, regularization of occupation. That, my lord, will find at page number 38. Page number 3. Annexure 11. To the Deputy Commissioner, such and such. Subject allotment of government land to private individuals at Bombila Township. Serial number 1 is my name. With reference to your letter or subject cited, I am directed to convey the approval of government for regularization of land allotment to private individual at Bombila Township on lease basis for a period of 33 years, subject to payment of general land value and annual lease rent as fixed by government from time to time from the date of occupation and fulfillment of other terms and conditions for allotment of government land. As on that matter, there is no proceeding pending against the petitioner for encroachment of government land. But be that as it may, the state of Arunachal Pradesh has not framed any pension rules for its employees. The Central Civil Service Pension Rules 2021 has been adopted. Madam, kindly take note. Under the Central Service Pension Rules 2021, there is no provision for withholding pension for encroachment of government land. Neither the state of Arunachal Pradesh has framed any statutory rules permitting withholding of pension and service benefits, even in case of those government employees who have encroached upon government land. Now, this being the position of law, the state respondents in garb of the two executive orders cannot act contrary to pension rules of 2021. In similar situations, this Honorable Court has already directed the state respondents to process the pension file without insisting on the NOC, my lord. One order, my lord, I have annexed at page number 38.
38?
Sorry, page number 39 by coordinate bench of this Honorable Court.
Achha.
Page number 39, honors, my lord. 11 paragraph, page number 41, last paragraph. Page 41. In view of the above, the instant writ petition is hereby disposed of by directing the respondent authorities to immediately finalize the pension papers of the pension and to pay to the petitioner the pension he is entitled to in terms of CCS Pension Rules 1972. This has been repealed by 2021 rules. Without insisting for NOC regarding non-encroachment of government land from Deputy Commissioner West Cameng District such and such. Therefore, I am praying for similar relief. Ola.
Yes.
Earlier, Lordship, no formal land allotment was issued to the petitioner, Your Lordship. That is why NOC was not issued, Your Lordship. Now that formal approval has been issued by the authority. So,
You don't have any objection?
yes, Your Lordship.
Okay, I'll pass you. Disposed. It will be disposed of. Okay.
May it please, Your Lordship.
Yes.
So it's a very limited prayer. And
Here, my lord, the petitioners are aggrieved by the action of the respondent number 3 and 4 for not registering the FIR, though it discloses a cognizable offense. My lord. That's the crux of the petition. The lordship will find the FIR at page 42.
Yes.
Well, may just read it to them. Upon receiving numerous complaints and substantial evidence, we would like to inform you about the illegitimate and fraudulent practices of the so-and-so board under the leadership of so-and-so, the former chairman, during the tenure of so-and-so, former secretary of the board, so-and-so OSD to the board chairman, so-and-so present finance accounts officer of the board, so-and-so present accounts of the board, accountant of the board, so-and-so member secretary of the board, and so RO come former OSD to the previous chairman, aided in fraudulent utilization of cess money meant for implementing welfare schemes for the benefit of poor construction workers in Arunachal Pradesh. As a result of their action, these workers were unjustly deprived of their rightful benefit. Here are some of these instances. That's why it is to inform that your office that every year since establishment of the Arunachal Pradesh Building and the reliefs which are sought in this repetition.
Yes, Mr. Tapping is wanting to use.
This is said, notice my issue.
We'll take instructions.
Possibly, my lord, there is nothing against the government. It is the SIC because the respondent number 3 and 4, it is the inaction on their part to register the
Yes, definitely. Issue notice first. You are appearing for, from?
Respondent number 3.
For 3 and 4.
May I just pray for one thing, Lord? Like instead of notice, if your lordship issue notice for instruction, if they can place it that this is not registered, because there's no disputed fact.
Notice, issue notice. In the meantime, they will take instructions also.
My lord.
Mr. Your?
My lord.
Your B. Kaushik?
My lord.
Heard Mr. B. Kaushik, the learned counsel for the petition. Also heard petitioner, full stop. This is an application on section 226 of the Constitution of India for issuance of writ in nature of mandamus and or certiorari and or any other writ, order or any direction. This application has been filed. I guess for the inaction on the part of the respondent authorities to act upon the complaints dated 9/11/2023, 5/2/2024, 15/4/2024, submitted by the petitioner for proper investigation. Issue notice on the private respondents, respondents as respondent number you are representing 1 and 2. 1 and 2. As the respondent number 1 and 2 is already appeared through the government advocate, senior government advocate, Mr. S. Tapping. No formal notice is required to be served. on the respondent number 1 and 2. However, the copy of the petition may be served within the the course of the day. In the same time, the respondent here for 3 and 4. So yours 3 and 4 in a sense, 3 and
It's a standing council, SIC can accept.
standing council SIC. As also heard, you are Mr. T. Minky, the standing council for SIC, appearing on behalf of respondent number 3 and 4. The formal notice is not required to be furnished. However, the academic so and so. It is submitted by Mr. Minky that they have to take the instruction from their department to file their affidavit in opposition. Accordingly, the respondent number, the standing council is hereby asked to take the instructions from the concerned department to file their affidavit in opposition. So how many weeks you need? 2 weeks. 2 weeks? It will cover 2 weeks. Take instruction whether it has been registered or not, what is the
That
purpose
much.
of jurisdiction, that much only.
That much.
And if it is not registered, suppose why, what is the reason? This kind of instruction you can take. List accordingly after 2 weeks.
Can I pray for a fixed date, like 25th of June? Maybe.
Want a fixed date?
Bala.
25th of June.
Grateful man. Hello.
Yes.
Lord,
Yes.
I filed this writ petition praying for issuance of a writ of mandamus against the action of respondent number 2 and 3, who had most arbitrarily set a hold on my credit balance of 40,70,000. And the instructions and which has not been released till date, despite my verbal request and also the representations on 2 occasions I had
Now, what
submitted
is the 18 lakhs? 18 lakhs?
40 lakhs.
40 lakhs have
70,000
been
is the
hit.
current balance.
Ah.
But Lordship, it has a background. The background story is that the respondent number 4 is my senior business partner. He is a registered firm. And I'm I'm the subcontractor in a way who associates with him in executing several works, government works under several work order, particularly the MES.
So you made him as respondent number 4 here.
Yes. And my arrangement with the respondent number 4 was that he, being the registered firm, whenever upon completion of the work order, the department releases the money, that money goes to the account of the respondent number 4. And thereafter, based on the check duly issued to me by the respondent number 4, I present the check to respondent number 3, and thereafter the amount is transferred from the account of the respondent number 4 to my account. And in the instant matter, on 13/7/2023.
So at
Lordship,
present,
my entire contention, all my grievances revolves around that 13/7/23.
and there was another plea that there was an arbitrary deduction of, and there was an of rupees 18 lakhs.
Yes, Your Honor, I am coming to that only. On 13/7, I came to know from the department that an amount of rupees 68,80,000 has been released. And that has been credited to the bank account of the respondent number 4 as per the arrangement arrived at with the bank. Because there was a standing instruction from respondent number 4 that whenever the money is released and credited to his account, that will be ultimately
Yes.
transferred to my account. So on 13/7, when I ascertained from the department that an amount of 68,80,000 has been released, I went to the bank to confirm. When I went to confirm the whether the exact amount has come or not. I was shocked that an amount of rupees 18 lakhs had already been deducted from my 68 lakh 80,000. And that has been diverted to meet some other loan, which were pending against the name of the respondent number 4. So when I resented, I lodged my complaint with the respondent number 3. He did not, he dismissed my, actually he did not entertain me properly.
Okay, then, okay. Sure. I
Then-
understand. Now you are appealing for?
I'm for the respondent number 1.
For 1. Okay. So you wishing notice on respondent number 1 has already appeared, 2,
Yes.
3 and 4. Okay, at this stage. Hard, Mr. You are Mr.
Lordship,
You are Mr.
for respondent number 2, 3 and 4. Notice is yet to be served.
No, no, yes, yes. No, you are Mr. Well, your name, good name.
Okay.
As Chetri,
Yes, Your Honor.
your good name.
My Dr. Tilak Dasgupta.
We are on 3. We are on,
Dr. Tilak Dasgupta.
no, 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 we are on item number 3. So your name is not reflected here?
In the Wakalatnama, I had signed, Your Honor.
Maybe.
In the Wakalatnama, it is there.
Hard, Mr.
Name is not reflected in this.
Hard, Doctor.
In the
you are
first list, I do not know, it is not reflected.
It's not reflected.
Wakalatnama
Anyway,
had signed.
so and so, this is Hard, Mr. So and so, Dewan Council for the petition. This is an application under section 226 of the Constitution of India, praying for issuance of writ in nature of mandamus or any other appropriate writ, order or direction for removal of illegal and arbitrary hold set on the credit balance of the petitioner amounting to rupees 40 lakhs 70,000 lying in SB account maintained by the petitioner with SEPA SBI branch, West Kameng district, Arunachal Pradesh, by the respondent number 3, disregarding due completion of transaction on 13/7/2023. Mr. এখানে নাম কি আছে না? Huh? No.
Tilak Dasgupta.
No, এক নম্বর কারণে appear button. So the learned council appearing on behalf of the respondent number 1, state respondent number 1. No, he is you are appearing on the strength of government advocate or
SDSC.
SGSC?
Respondent number 1.
Respondent number 1. No formal notice is required to be served on the respondent number 1. However, issue notice on respondent number 2, 3 and 4 to registered AD and as usual process, returnable within 4 weeks. List the matter accordingly on 4 weeks. Are you going to file any?
No. Basically,
You are
3
the
and
formal
4
party, I think.
2 and 3 are the
Main.
respondent.
Okay. After 4 weeks. You take steps within 7 days to respond number 2, 3 and 4.
Lordship, can I get 2 weeks time? Because I am an outstation actually.
2 weeks time to take steps.
No, we'll take steps to this. We will.
Take steps within
Yes,
within a
yes,
week. It
yes,
will be
yes,
listed
yes,
after 4 weeks, but
yes,
it
sir.
has to be returned. Actually.
Okay.
Item number 4.
This, your lordship, here petitioner is yet to file rejoinder, so I may be given some time to file a rejoinder.
Rejoinder.
Yes, your lordship. Affidavit in reply.
You are for? He is for?
State.
State.
Lordship.
You are Mr.?
A Bhattacharya.
No, you are appearing for A Bhattacharya.
I'm appearing for the petitioner.
Yes, you are appearing for the petitioner on behalf of A Bhattacharya.
I'm A Bhattacharya.
Oh. Okay, Doctor. Heard Mr. A Bhattacharya, the learned counsel for the petition. and is submitted that the rejoinder, you want to find rejoinder?
Yes.
Rejoinder affidavit is yet to be filed, and hence he needs some more time. Also heard your Mr.
I agree.
I. Iram, the government advocate
Yes.
for the state respondent, and he raised no objection. Full stop. List how many weeks you need?
After 4 weeks. you know,
After 4 weeks.
3 weeks, no,
List after 3 weeks, enabling the petitioner to file their rejoinder affidavit.
all right.
Item number 5.
Challenging the impugn advertisement
Hmm.
and also rejecting the application of the candidate. Well, for the Anganwadi, well, it is like this. There is a village called Bam in Basar. So the Bam village has 5 to 6 small centers. The Yorte, Hite and all those. But then the CDPO have illegally rejected my application, saying that I don't belong to that particular village, and therefore in violation of that guidelines. My lord. Now, my lord will see that impugn advertisement is at page 19. My lord. Education, my lord, I am qualified. My lord.
Page 19.
Page 19, annexure 2. My lord.
Yes.
Dated 27th October 2021. Application is hereby invited from eligible candidate of only Bam Heker Center to fill up the vacated AW worker post of Bam Heker Center. My lord will mark this word Bam Heker. Bam is the main, my lord, village.
You are on page number 19.
19, my lord. Impugned advertisement.
Just a second. Yes.
Yes.
So you emphasize the word on Bam.
Yes. My lord will only mark first that second line. There is a word called AW stroke worker post of Bam Heker. The word Bam, my lord. Interested person stroke candidate may apply for the post of AW or worker who willing to serve on honorary basis, terms and conditions. My lord. So, my lord, the first condition, number 1, is the important, my lord. Candidate must be inhabitant of Bam Heker area household, my lord. Well, this is exactly against this, my lord. I have submitted my representation at page 20, my lord. This is, my lord, how I have described in my representation that this impugn order is not in consonance with the objective of Article 14 and 16 of the Constitution. The clarification that I have given is, my lord, 1, 2, 3, 4, 5. Well, the 6th line at page 20, my lord. 6th line, first paragraph, 6th line, my lord. I am inhabitant of Yorte Center area. Interestingly, Heker Center is located at Yorte area, and Old Bam village is divided into 6 area, namely, my lord. Now, my lord will understand that I said in my opening submission, my lord, I made a statement that Bam is the main village, my lord. So there, these are spreaded to the first Yorte, Heker, Pomte, Pugra, then Bane and checkpost, my lord.
Now, these includes the Bam Heker Center.
Yes, Bam is the main center. So therefore, there is a hostile discrimination in rejecting my application, my lord. Now, my lord, to fortify my argument, my lord will kindly come to page 24 straight. Guidelines, I mean. No, my lord will kindly come to page 22 first.
20.
And annexure, yes. Thereafter, my lord, I'll rely what?
23.
Page 22.
22.
22. We have asked for the guidelines, under what guidelines the recruitment is to be done. They reply by the Child Development Project Officer, Madam, with respect to your subject representation for cancellation of advertisement, number so and so, dated so and so, submitted by your end, it is to bring to your knowledge that the Government of India guidelines DO number so and so, CD submitted by you has been changed under the new guidelines of Arunachal Pradesh Terms and Conditions of Service of Anganwadi Workers and Helpers, their roles and responsibility guidelines 2019. So in these connections, your area don't fall or come under jurisdiction of BAM Hikar for the advertisement page 22, for which the advertisement has been published and your application has been rejected, cancelled under the new guidelines of Anganwadi worker and the helper. Now, my lord, this particular guideline, it is there, my lord. Now, my lord will come. Then page 23, my lord, we have requested for the guidelines. And these guidelines was not provided to us. No problem, engineer. Now, the annexures, my lord, which I have referred to is at page 24, is annexure number 6. These was the conditions, my lord, which I was eligible in this, my lord. That, my lord, page 24, October 18 to 10, 2010. Is written to one Dr. Singh. It is by Dhirendra Singh. Yes, all states, my lord. My lord will see, as you may be aware, the Government of India guidelines for selections of Anganwadi workers, AWWS, under the ICDS scheme provide that the Anganwadi worker should be a lady 18 to 44 years from the local village and acceptable in the local community. Now, my lord, this particular sentence on a smaller scanning also, my lord, we'll see that fortify my arguments that I am eligible because BAM is the main village and there are centers. So once BAM is the primary village center, then there's the end of the map. Well, these particular guidance. Now what happens is, it simply fortifies my argument by their own affidavit. Well, we'll kindly have this affidavit. Their state government affidavit opposition by respondent number 1. Now, para 3 at page 2, that with regards to the statement made in paragraph 1 of the read petition, the answering respondent begs to state that prior to the notification of Arunachal Pradesh terms and conditions of service of Anganwadi workers and Anganwadi helpers, their role and responsibility guidelines 2019, there was no comprehensive to deal with recruitment of AWW/AWHS except the Government of India letter issued, my lord will mark this. Government of India letters issued from time to time, and therefore the feeder area cadre was not followed while conducting selections of Anganwadi workers. Where the village is very large and there are more than one AWC in that village, the feeder area norm is essential to select the right candidate from the respective feeder area of the Anganwadi center. In fact, there are 5, which they admitted, there are 5 AWCS in BAM village, and therefore AWWS were selected from BAM village irrespective of feeder areas of norms. They admitted. Now, my lord will kindly come to page 11.
Page 11, para 11.
Of their affidavit. Now, this is the, my lord, the integrated guidelines. 2009, this is centrally sponsored scheme. ICDS, my lord knows that is a centrally sponsored scheme. My lord will come straight to the relevant portion at page 12, my lord. Now that serial number 3, my lord. Eligibility criteria, my lord. Only, my lord, such female candidates are eligible to apply for the post of Anganwadi worker, Anganwadi helper who fulfills the followings. A, ordinary resident of the village in case of rural area. No, my lord, for a moment, my lord, just I place a small for lordship's clarity on that Kuldeep Nair versus Union of India judgment, but that is relating to Representation of People Act. But the meaning of the word ordinary resident is defined, my lord. That is just for the definition purpose, my lord. Just this is one of the celebrated judgment, my lord. But that only for the definition of term ordinary resident, I am placing it. My lord will take on the call. A, my lord, we have seen ordinary resident of village in case of rural area. Now, which is my ordinary resident of place, my lord? The BAM village. According to their statement itself, my lord, there are 5 centers in the BAM village. So therefore, on the first count, I qualifies. Word, in case of urban area where Anganwadi center is located or belongs to feeding villages, words of the Anganwadi center, Anganwadi area. If the candidates are not available within the feeder area, here, my lord, they are trying to interpret that I don't come under the feeder area. But I am from the feeder area, which, my lord, I have already defined in that. If the candidates are not available within the feeder area, application can be invited from desirous candidate residing within the area of the concerned Gram Panchayat in case the feeder area falls into Gram Panchayats. But our is not in this category also. The same Panchayat. Huh? Now B, for Anganwadi workers, minimum qualification is this sentence. So, my lord, what? Huh? Well, there was one more thing. While passing interim order, my lord, kindly have this, if this order is there in the court, 12/11/2021, while passing the interim order.
Yes.
Lordship, Surana has passed this. Para 6, my lord. It appears from Annexure 3 of the read petition that in Old Balm village, there are as many as 5 Anganwadi centers, being Yorte Center, Hikar Center, 3 Pomte Center, Pugra Center, Bane Center, and 6 Checkpost Center. And it appears from Annexure 6, DO number 1-13/2010 CD1, my lord, which I have referred to in this. Dated 18/10/2020, that the Government of India guidelines prescribe that the Anganwadi workers should be lady between 18 to 44 years from the local village and acceptable in the local community. What is this word acceptable in local communities? I am a Galo, born and brought up. And this area, I am from that area, I can communicate with the villagers. There's the thing. In this regard, the assertion of the petitioner is that she is a resident of Old Balm village. There is no more quarrel, no dispute, Miller. It's very loud and clear. Now, para 7 is important, Miller, by granting the. Therefore, as herein before referred guidelines dated 18/10/2010, having not investigated that the applicant should be resident of the Anganwadi center, but the applicant should be a lady from a local village. This code is inclined to provide as an interim measure till returnable date that the respondent number 2 shall not proceed further in the matter of appointment of Anganwadi worker for BAM Hikar Center. However, if the village BAM Hikar Center is a distinct village from Old BAM village, these order would not stand as an impediment for respondent number 2 to proceed with matter of selection and appointment. But that word, however, the adjectives, there, his lordship has made an observation that if that particular Bamhikar is a distinct village from the center, then I have no case. Because of these interim order, they are not able to proceed with law. And that meaning thereby, and in their affidavit, my lord, this particular aspect is completely silent, my lord. So, my lord, that's why on the legal point, my lord, though the matter is very small, I'll indicate those judgments, my lord. I'll not read it out. Now, this, according to the action, to my understanding, in respect of the respondent number 2, is not in accordance with the guidelines. So therefore, my contention is justified, my lord, even in terms of that interim order and also both the guidelines, my lord, which they have annexed, 2010 and 2019 guidelines. It fortifies my argument, my lord. Now, my lord, he is not empowered to reject. Respondent number 2 is not empowered to reject my applications. So, what's the name? Is not empowered to order. So, my lord, that is one aspect which I want to say, my lord, that is submissions. Now, my lord, even, my lord, if it is an administrative decision to reject, but the decision must be well informed and with reasons. But my lord has seen that impugn rejection order. Absolutely no whisper about any reasons, my lord. So therefore, that, my lord, that Dalip Singh judgment, my lord knows, very old judgment, 2010, 13 SSC, my lord, page 427, paragraph 30. I'll just provide that letter point. Then 2010, my lord, 9 SSC, page 496. Paragraph 23, 28, 47, the necessity of giving reasons, my lord. Now, my lord, the last one is that 2016 1 SSC 724, paragraph 4, 7, 8, and 14. Administrative and executive decision must be in consonance with a rational nexus. And here it is absolutely absent, my lord, for the reasons that if you are to disqualify a particular person or the candidate, you ought to give the reasons that you are not bona fide resident of that particular area. Number 2, you are not qualified. You don't have required educational qualifications to claim for the post. So therefore, the entire action is arbitrary, my lord, and this must be interfered with and direct the respondent authority to proceed with issuing press advertisement. Or, my lord, alternatively, what I'll suggest is to continue with that, accept my applications and evaluate the entire process, so that I am allowed to participate in the interview process. Not that much. I don't know my brother what he will say.
Lordship, in fact, it is an admitted fact that the petitioner is from Yorta village. And whatever we are speaking about, the center is from Hukar. So
No, he is from?
Hukar means the area is divided into some by name, the village. So in that Bam village, there are 5 Anganwadi center.
Yes.
And the petitioner is from Yorta. And what we are calling for advertisement is at Hukar.
Bamhikar.
Bamhikar. So Lordship will see at our affidavit in opposition, page 9, Ferrite.
Page 9.
Ferrite. Earlier, it was funded by, mostly funded by the center. Now we only get 10% from the center and 90% is being funded by the state. Therefore, Lordship, this Arunachal Pradesh Terms and Conditions of Service of Anganwadi Workers and Helpers and their Rules and Guideline 2019 was issued, Lordship, notified. So, Lordship, 3, 4, 5, 6, 7. I will read from para 8, Lordship, 8, para 8 and 8. In terms of the para 3 of the said notification, the candidate should be an ordinary resident of the village in case of rural area. It is admitted where Anganwadi center is located, Lordship, because it is located at Hukar, not at Yorta. If the candidate are not available from Pidar area, application can be invited from desirous candidate residing within the concerned Gram Panchayat. That means if your day is nearby, but if they fall within the same GP, if we don't get any desirable candidate from Hikar, we can go from, we can take from other nearby center, only nearby center. In this case, there are 5 Anganwadi center in Bam village, and as such, candidate from Pidar area should be given first preference. And if no suitable candidate is available from Pidar area Anganwadi center, then candidate from Gram Panchayat will be considered. So she was not considered because she did not fall area from the Anganwadi center, Lordship. And this was issued in consonant with, Lordship, Arunachal Pradesh Terms and Conditions of Anganwadi Workers and Helpers and their Rule Responsibility Guideline Notification, Lordship, 2019. So there is no illegalities or there was no arbitrariness in rejecting the petitioner because she did not, she is from another area, and what we opted was for Hikar area.
Small presenter. I think my brother, you're done? Can we have their affidavit again? The main contention which I have raised in paragraph 11, 12, and 13, what they say, well, this particular para 11 of my petition and this, may I have a tally for a moment?
Your para number?
My paragraph 11, 12, my lord, and 13. Just assisting, my lord. What they say, my lord, in their affidavit in opposition, that is also in paragraph 11, my lord. They say that with regards to the statement made in paragraph 11, 12, and 13 of the writ petition, the answering deponent offer no comments being the matter of record, my lord, but denies all those which are not born out of record. That is a fundamental sentence. So therefore, the contention that my learned friend tried to confuse successfully is absolutely unfounded because they have not denied it, meaning thereby they have accepted, my lord. That old judgment is there, 1972 SCR, my lord. I forgot the page, my lord. Government cannot go against its own document.
Lordship, we are not following the guideline of Government of Indian guideline now. We are following our own guideline.
No, you have made your own statement. Again, you said, except for the state notification of the government. So you are,
no,
there seems to be a lot of contradictions. Paragraph 8.
It was.
No. Kindly come to paragraph 3 of their affidavit. They simply say that there was no comprehensive to deal with recruitment of Government of India letters.
It was in earlier time when the government of India funded maximum sharing. Now the government of Arunachal is funding the maximum sharing. That's why we are following the rules framed by, this guideline framed by government of Arunachal Pradesh, nothing.
Yeah, anyway, my lord, just may I request my lord kindly have my paragraph 11. Yes, I want to read out so that everything becomes very clear.
Yes. what
Yeah,
is it?
my lord, kindly page 9 of my read petition, my lord. That I am at page 9, my lord, that the petitioner respectfully submits that the impugn advertisement dated 27/10/2021, as well as impugn rejection order dated 02/11/2021 is in contravention of the Government of India guidance for selections of Anganwadi workers issued on 18/10/2010. As such, impugn advertisement issued by respondent number 2 by inserting own terms and condition is illegal and arbitrary, as because in Central Government Guideline 2010, the Anganwadi workers would be a lady from local place and acceptable in the local community. 12. That it is to submit that in all BAM village, there are as many as 5 Anganwadi center, namely Yorte Center. Milord will see in Yorte Center, MS Pagi Bam, wife of Sri so-and-so Bam from Hikar area, is working. Milord, kindly see the first thing which their contention falls flat here only. Now, number 2, Milord, Hikar Center, which is the center here. In Hikar Center, MS Rinya Bam, wife of Sri Gamdo Bam from Bane area, is working as helper. Now, I have come with the clean hands with all justified reasons. Even 3 check post. There in check post center, MS Dumik Bam, wife of Sri Jungo Bam, teacher from Bane area, is working as worker. 4 also similarly sent Odak Bam from Pomte area. Again, another from a different place. So why in my case? Therefore, in their paragraph 11 of their affidavit in opposition, they have not controverted my contention, so it holds the field, and well, that much.
Lordship will say, see at our para 12 also, we have not we are here we have said that, Lordship, the answering the respondent backs to page 9, para 12, Lordship. The ICDS, where these people were appointed, it was governed by the central guidelines. Now, Lordship will see that the ICDS scheme is no more flexi program of central government for mainland.
You are in para number?
Lordship 12,
12.
page 9. The answering respondent back to the ICDS scheme is no more a flexi program of the central government for mainland states like Kerala, Tamil Nadu, Karnataka. The cost sharing is 25/75 by center and state. Only notice that the cost sharing is 90/10, 10 by center. Moreover, the central government is discontinuing funding payment of many regular staff which were originally created under ICDS scheme. A Anganwadi worker is paid an Anganwadi honorarium of 6,500 month out of state bears 2,450. And as such, the state guideline on recruitment and service contribution applicable for recruitment of Anganwadi workers, which was done by earlier, they cannot compare it now, Lordship. Now we have our own guidelines, and whatever has done, it was according to the new guidelines framed by the state, Lordship.
It is, Lord, any centrally sponsored scheme, if it is to be discontinued, the government must come with a clean hand with a notification saying that the center has discontinued this scheme. You have framed guidelines for a different purpose, but still 2019 guideline is there, my lord. That guideline has not been overturned.
Yes, we have notified.
No, I don't think. It is not.
Lordship, you will see at page 10, Annexure 1.
In any case, my lord, just I concluded my submissions. My lord will pass appropriate order. A small matter, my lord. Why a person should be deprived of? Let there be a and healthy participation of the candidates within that. Grateful.
Yes, what are you saying, Lecture 1?
Lordship,
Page 10?
phase 10, Lordship, in our affidavit.
That much, right? Notification.
Oh, no, Lordship, that is notification, Lordship. It was already notified.
Service condition, my lord.
Service
This scheme has not been discontinued. This is service conditions only. I'll read out for my lord. The governor of Arunachal Pradesh is pleased to notify the Arunachal Pradesh terms and conditions of service of Anganwadi workers and helpers, their role and responsibility guideline 2019 for the purpose. ये कौन सा date करेगा?
After center discontinued that,
For the
when
ये
it
वाला, 2019.
increased, we have notified.
For the
Lordship,
further, all the child development under the government of Varna ensure government terms and conditions of service of helpers and their role and responsibility in accordance with this guidance. Well, the scheme has not been discontinued. There's only
No,
it cannot.
if the government says scheme has been
No, but-
discontinued and still funding system has been reversed.
No.
No.
Submission from the record.
I'm submitting on the record only from my
No,
affidavit.
my lord, in this case.
I have read out.
Once the center.
I have read out.
Yeah. Just 1 minute.
Para 12.
Just 1 minute. Just 1 minute. My lord, what happens is, suppose in case of there is a conflict, then my lord will always refer to Article 247. Then read with the 7th schedule, the union, state, and the concurrent list, my lord. So in case that is, my lord, that 47, even that Inter-State Council Article 263, my lord. You see, my lord, whatever that Kaveri water dispute case, if my lord recall that, then ultimately what happens, that is the purpose of constituting the Inter-State Council, my lord. Now, unless my lord, what happens if in terms of the constitutional mandate, any rules made by the center will always prevail over the states. Unless or otherwise there is a concurrence from the parliament. Fund sharing is still there, my lord, according to their own statement. In any case, my lord, grateful. My lord.
Let me see if I can read. I have some other works also. If it's possible, I may pass the order by Friday also. But at this stage, it will be reserved. If it is convenient, I may pass the order tomorrow also or day.
No, my lord will have the own time. My lord, that
Reserved
interim order to
amount.
continue, my lord.
Oh.
Interim order to continue till
Yes.
judgment. That sentence, my lord, will make the statement.
I will reserve for it.
Huh?
Interim order be continued till next date of listing.
Grateful.
Okay. Till the judgment is pronounced.
Yes.
Item number 7, my lord, I would like to withdraw this petition, my lord.
Item number 7, you want
Yes.
to withdraw?
Yes, my lord. They have released our compensation amount.
6 already. Item 6. What? Oh, acha, just see me now. Now, item 6 is already mentioned. So we are on item 7 now?
The matter
Yes.
has become infructuous, my lord.
Infructuous.
Yes, my lord. They have released our compensation amount.
We have already released. Okay. They have released your
Yes, yes,
entire.
yes.
Heard Mr. J. Nini.
BB.
B. Bicha, the learned counsel for the petition. Also heard MS Swenson, the learned government advocate. It is submitted by Mr. Bicha that the matter has already become infructuous as the state respondent has already released the amount. Accordingly, he wants to withdraw the same. Matter may be disposed of on withdrawal accordingly. Okay, it will be disposed of
Wonderful.
as
Okay.
become infrastructure.
All right.
Ma'am, also,
Just a second.
on behalf of the box,
Just a second. What will-
eight. May I also, on behalf of the box, he instructs me, we will. The box. He instructs me, we will file a reply.
We have already filed affidavit, madam. They want to file rejoinder. Yes, madam. And my lord, there are some analogous matter, my lord. So may I pray that that matter may be tag along with that matter? Yes, madam. Read petition 307 of 23. Yes, madam. And read petition number 311 of 23. Yes, madam.
3 weeks.
Yes, ma'am. Obliged. May I, your lordship? Lordship, this matter, if it can be heard and disposed of today itself, because it's a very small prayer, your lordship. So here we are assailing the order that was passed by the Deputy Commissioner, your lordship, dated 2024, whereby I was directed to vacate my quarter within 10 days of receipt of the 10 days from the notice that has been issued, your lordship. That is in page number 15. That is the impugn order, your lordship. Page number 15, 15. Page number 15, annexure 1, your lordship. 15. So this is the order. Now what happened here, your lordship? That is, I was given only 10 days of time. So instead of the quarter which I am residing, that was not illegally taken, your lordship. I was given that quarter. White order dated 7/12/2018, your lordship. 2018, that quarter I was given. Now what happened is they have issued one more notice prior to this, your lordship. That is order dated, if your lordship will see, it's in page number 17, annexure 3. The type copy is in page number 18, your lordship. So 1st February 2024, I was issued order stating that in the quarter which I have been assigned due to their overlook, and they have given the quarter, and thereby I was assigned to another quarter at near Medical Colony. So that is there in page number 18, your lordship. So now I had filed a representation before the Deputy Commissioner as well as the DMO, stating that I have a medical condition. When I have filed this application, your lordship, I was 30 weeks pregnant. So in that condition, plus my pregnancy is a high risk. I had 3 miscarriages already, and through IVF only I I was able to conceive, your lordship. So now that being the reason, because 30 weeks, it's very important period and it is not possible for me to shift. Plus I have two toddlers, out of which they are twins. One, your lordship, sadly, it's borderline autistic. So even for her, medical treatment is going on. So those were the conditions which I have informed the DMO as well as the Deputy Commissioner, praying that at least I may be given some time. After the delivery, I will vacate the quarter and will shift to the quarter which they have allotted. I have not challenged the order that I will not vacate. I've clearly stated that yes, I will vacate. Just give me some time and then I will renovate the quarter which I have been allotted and pertaining to my medical conditions, your lordship. So the DMO, the district medical officer, forwards a letter stating that my prayer may be considered considering the medical conditions to the Deputy Commissioner. Now, when I see this, I was in a construct that yes, my prayer has been allowed and I may be allowed to stay till the delivery of my child, your lordship. Now what happened is, thereby this impugn order again was given to me on 26/3/2024, which I am challenging before this honorable court. So in this order, I was stated that within 10 days, I have to vacate the quarter and shift to the quarter which I have been allotted. Now, if your lordship will kindly come to page number 36, your lordship, that is my annexure 9. Page number 36, annexure 9. Now, this is the quarter which I have been allotted, your lordship. The condition of the quarter, nobody has been residing for more than 1 year. It's in a completely dilapidated conditions. Even the basic amenities are missing in this quarter, plus the condition which I am in. So it is not humanly possible, your lordship, to shift within 10 days. That's last notice, 26/3/2024, your lordship. March, your lordship. Then I have filed this application, your lordship, in the month of 4th April. So 10 days time was given. So as of now, your lordship, pertaining to my conditions, your lordship, the medical condition is there for me as well as my child, your lordship. And looking at the condition of the quarter, which I have been allotted, it is not humanly possible to, your lordship, I was supposed to deliver the child in the month of this June, your lordship. So now what happened, my medical conditions, since I have lots of medical conditions, the child was recently delivered prematurely. And as far as I have been informed that the child is in NICU, your lordship. So my prayer before this honorable court was only to give me 6 months of time, your lordship, and I will vacate the quarter. By the time the child is delivered and then the quarter is renovated and I will shift, your lordship. So as of today, only 4 months remains, your lordship, according to my prayer. So this matter can be disposed of only 4 months, your lordship, till the month of October, and then I will vacate the quarter. Because we are not challenging that, we will, lordship, the order, it's in page number 15, your lordship. Yes, your lordship, annexure 1. Yes, your lordship.
Your Mother, I've received instruction, my lord. According to our instruction, quarter has already been allotted to her, my lord, which she have already stated in her. Yes, my lord. Yes, my lord. It was there. Otherwise, my lord. Otherwise, my lord, you can, my lord can dispose of the matter, my lord. No, my lord. I think, according to me, my lord, I think it will be better if this matter will be disposed of today, my lord, because already 2 months has left gone, my lord. 6 months, already 2 months. Yes, 4 months is there. Yes. Yes, my lord. Specific time, yes, my lord.
Artaku, your lordship. R Taku. In the
It's in third, ma'am.
third name,
Third
Your
Malad.
Lordship. Third name. Yes, Your Lord. Your Lordship, it's in page number. Yes, Your Lordship. Page 17, Your Lordship. That is not clear. So type copy is in page number 18. Your Lordship, it's in page number. Yes, Your Honor. Page number 16.
Punibasana at Medical Colony, and thereafter, on receiving the said notice, the petitioner has submitted a representation before the office of the Deputy Commissioner, bracket of respond number 2, dated 6/2/2024, which was submitted before the DMO's office, whereby the DMO by the office that uh, 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 before she already did the abortion. Your 3 times abortion was also there, no?
Your Lordship.
No, your pregnancy, you have 2 toddlers
Yes.
and 3rd time pregnancy.
And this is the second time, Your Lordship, because earlier 3, they all had
As
miscarriages.
submitted that earlier 3 occasion, the earlier 2 occasion her pregnancy was aborted, and hence she has some medical emergency and was not in a position to shift her quarter within the stipulated time given by the authority concerned. More so, the quarter which she has been allotted is in dilapidated condition and is not fit for and is not fit for residing in the quarter with her 2 minor child and in at the stage of her pregnancy. She further submitted that at this stage she has already delivered a premature baby, which also needs care and he or she is under still the doctor
Medical.
cares, na?
Yes.
She under care of the doctors and strict vigilance of care and strict vigilance of the doctor. So accordingly, the present application was filed seeking at least 6 months time, na? Submitted that the present application was filed seeking 6 months time to vacate her earlier quarter so that she can renovate the quarter which was allotted to her and can shift in the said the quarter. So it also reveals from the your interim was on 4/4.
Yes, Your Honor.
And it also reveals from the record that by the order dated 4/4/2024, the interim order was granted, and interim relief was granted to the present petitioner. By suspending the order passed by the Deputy Commissioner dated 26/3/2024 to 2024. Full stop. She accordingly submitted that it has already lapsed 2 months. 2 months has already been lapsed, and she needs only 4 months to vacate the quarter and to shift shift to newly allotted quarter to her. Full stop. Next para. In this context, MS so the Learning Government Advocate, submitted that considering the medical condition of the present petitioner, and also considering the fact that 2 months has already lapsed from the order passed by the Deputy Commissioner, the state respondent has no objection if the petitioner is allowed to stay in the earlier quarter for another 4 months. However, if by 6 months you want to vacate, however, it is submitted that within these 6 months, the petitioner should vacate the quarter, and she may be directed to shift in the new quarter allotted to her. Next part. Considering the entire submission made by the Learned Counsel for both sides, considering the medical urgency and grounds mentioned by the present petitioner, and also considering the fact that the present petitioner is seeking only 6 months time to vacate the quarter and to shift in the new allotted quarter to her after renovation. Allow. However, it had a last direction, however, she is strictly, however, she is directed to vacate the quarter within 6 months from within 4 months over this time. Within 4 months from the date of order. With the above observation, yes. Okay.
Lordship, otherwise, after the completion of 4 months, otherwise, before 4 months is over, if she
Okay,
is-
then, okay,
that's
after
fine.
completion of the
After
4 months,
completion.
okay.
Deeply.
Oh, that's what I'm just asking you. I did not mark here. So you were on 6, item number 6.
Item 6, Lordship.
That's what I'm just asking him.
Yes.
Whether 6 has left, he said already mentioned. Actually, generally what had happened in course, I marked everything.
Yes.
What has been listed or what was it ending. So now 6, there is no marking. That's why I was just asking him. Whether
Lordship,
6
no
is
consent
already.
was also obtained. I was here since morning, but there was no consent also obtained. They mentioned before your lords and have.
No, it is not mentioned.
It is not mentioned.
Not mentioned. He
Wait.
is submitting that it has already been mentioned.
No, it's
No,
not.
not mentioned. No? Not mentioned.
Not mentioned.
But he is submitting that it has already been
I
mentioned.
also got into
thought
the
that
belief
when it
it's-
is mentioned,
No.
because there is no mark in my cause list. Anyway, what is this matter?
Lordship, there's a very small matter.
No, you are for the petitioner?
I'm for the petitioner company.
So, standing counsel, Mr. Jimmy Tarak was there, the T Tarak, RWD. He is available here today? Asani, na? Your nine? He is from Guwahati and he is of PSA.
Lordship, what has transpired so far is that a supply order was issued to me to supply bitumen. Bitumen is a product that is used for road construction. Accordingly, in the year 2021, I have supplied those products with the conditions that after a month, the payment shall be made. Now, the payment to all the private respondents have been made, but I'm still awaiting for my part to be paid. Now,
So if they have any instruction,
we
can.
have, Lordship, in the year 2022, Justice Arundev Chaudhary sir has told them to file their affidavit. They have failed to do so for last 2 years now.
Oh.
So, Malas, if applying the doctrine of non-traversa, Order 8, Rule 5 says that if they're not denying it, then
Okay,
all
that
my
will do. Can you be, will you be able to stay up to 2?
up to
Or we
Lordship, yes.
can just inform them. Inform কৰিব পৰা কিবা আছে সুবিধা? Can you inform the standing council of RDW? Just wait, if it can be informed before 1, we'll take up the
Lordship,
matter.
I'm here.
Or otherwise at 2, definitely.
I'm here.
Sile option, standing council cover. It was there only, in fact. Hmm? 16, he was there, na? In item number 6, in 16, in fact, he was there.
He was there.
Yes,
That's
so
what,
we have,
when he mentioned item 16, I also came up to see that is he mentioning 6 or 16? I misheard. But I think that is what happened with him also. He has marked 16 with that contentions.
She may inform.
I'll also try to get a hold
just
on him.
you, we are trying. Okay, we are trying.
Otherwise, my lord, if there is no other way, then lords may will do it in the chambers, just passing of dates. My lords may not sit because I think all other matters are over now.
No, we have some hearing matters.
Then I'll wait for one.
Otherwise, we'll see at 2 what happens, or prior to, if it can be.
I'm here, Lordship.
Then you just remember. But item number 21 and 22
Yes,
are together?
Yes, Lordship.
Analogous.
Analogous method, they are relating pertaining to the same issue, Lordship, and regarding the same incident. May I, Lordship? In nutshell, Lordship, I'll just in brief it. Lordship, what has happened in this matter is that the petitioner before this honorable court are a police personnel. They were deployed in a judicial custody to look after in Rowing police station, in a Rowing judicial custody. There were 5 of them, Lordship. I'll just in a brief. From their Lordship, one person, Mr. The Mokenango, was like on his misconduct on his when he was deployed as when he was in his duty. The 3 prisoners escaped from the judicial custody, and because of that, Lordship, all of us were imposed a penalty. And since finding that the Constable Mokenango, who was the person reason for the escaping of that 3 UTP, and Lordship, he was his name was struck from the police personnel. But Lordship, during course of time, Lordship, he had filed a review petition. His review petition was considered, and he was inducted back into the in this service. But our prayer, our review was not considered by the police authority. On that basis only, Lordship, we have come before this honorable court, taking a discrimination against us, Lordship.
How many police officers were there?
There were 5 police personnel. Lordship, as you know, Lordship, the condition of our judicial custody is a very small. And Lordship, in their inquiry of report also, they have said things like there were 5 of us. We have made a roster
I mean, from whose custody the accused persons were?
from the Constable Mokenang. During his,
From the lockup or from any bus or
from the lockup, Lordship.
Lockup.
From judicial lockup.
Judicial lockup.
I'll come to that, Lordship. Lordship, what has happened in this matter, Lordship, why we are before this honorable, because of discrimination against us. Lordship, what has happened in this Mokenang? There were 6 of us were like deployed for 1 month, Lordship. And during this 1 month, we have made a roster that from time to 1 hour of period, like everyone has to do their own duty. And during the time of Lordship, this Mokenang, what he has done is that during his it was his duty, what he has done, he has asked one of the UTP to massage his body. Lordship, to extend that, Lordship, he had consumed some alcohol with him also. And Lordship, in their inquiry also, it's a admitted fact, Lordship. At that point of time, no other constable or no other police personnel present. Since Lordship, like once the duty is done, the others go to his home. Taking rest again, now it's a routine. And he had consumed some alcohol. And Lordship, he had sent the UTP to purchase alcohol also. And during seeing that, Lordship, the one of 3 UTP, seeing that the constable is drunk, he was drunk. So Lordship, what they has done, they had pushed him inside the judicial custody, lock him, and they fled from the judicial custody. That is the fact, Lordship.
I mean, that it was not locked, I think.
They had
Lordship, I mean, because they are under the heading of alcohol, so it was not locked.
Lordship, like what has and since the constable, he was drunk, and he had consumed alcohol with the other UTP. So what the UTP has, and taking that in charge, they had pushed the constable inside the judicial custody, locked him, and they fled from this one. You're not. I'll just not taking much into. I'll come into memorandum of charges was also there. So like since the 5 of us, Lordship, the 5 constable was. I was the head constable, that is Wang Ham Loang, Lance Naik. There are 6 of them, Lordship. I'll straightway come to Lordship today. I'll come to page 22 of my petition, Lordship. This was the inspector circle of Lord Dibang was given since an inquiry report was prepared by him. Page 22. My petition, Lordship. 21.
Okay. Item number 21.
Yes, Lordship. Page
It's
22.
not legible one, I think.
Yes, Lordship.
It's not legible.
Yes, Lordship. Even here in my, I'll take the Lordship. Sorry,
The enquiry report is here.
Yes.
You want to present the enquiry report or
Just I
22?
want to show that, Lordship, like how they had distributed their work, and even it's reflected in the inquiry. Lordship, I'll take to item number 22. This is more legible. Page 26 in page.
Item number 22, it is page 26.
Yes, Lordship. They have typed copy. They have made it. Yes, Lordship. The inquiry report is prepared by the Inspector Circle of Police. It says on the inquiry report, may I send? The incident pertaining to escape of 3 UTP from judicial cell took place in the duty hour of Constable so and so, who was Lordship, who was detained from duty on 10/11 of 2007. As per the duty registered of 10/11 of 97, the claimant of BN personnel at judicial custody was as under. Lordship, it says the serial number 1, that is, I am the head constable L. Loang, to
So
Lance Naik
you are in which number?
Lordship, I'm
3 and 5.
1, your Lordship, 1. head commander, head guard commander.
Acha, guard commander.
Yeah.
Acha.
And Lordship,
So your duty hours was not fixed?
Lordship, since I'm the
Duty hours is not here?
my duty hour is not fixed. Since I'm the head commander, my duty is to deploy them, Lordship, to keep
Okay.
them to rest or roster.
Yes,
rest.
yes.
This will be from 1 hour to 2 hours. That will be that is my as an whole. That is was my duty, Lordship. And petitioner number 2, Lordship, in item number 2, he's a Onsen Wangpan. That is, item number 22. His duty hours given from Lordship 800 hours to 1600 hours.
So you are 1 and 2?
1 and 3, Lordship.
1 and 3?
Yes, yes.
1 and 3.
3
1 and 3, na?
for Sun 1.
It says from morning 8 to 4 in the evening.
No. Morning 8 to 10.
8 to 10, Lordship. It's 8 to 10.
And here's 16.
And from 16 evening 4 to 6 in the evening.
and 12.
And from 24 hours, Lordship, it's given
12.
here. And Lordship, the incident happened in presence of serial number 5, M. Ango. It's an admitted fact, Lordship. As the inquiry prepared by this Circle Office of Police, may I read you on it? It says, on 10/11 of 2007 at about 2000 hours, that is 8 p.m., Constable Moken Angu, who was on duty guard from 8 to 10 hours, that is 8 p.m. to 10 p.m. hours, took UTP so-and-so and accused of murder case and directed him to massage his body. Accordingly, UTP so-and-so started to massage the body of Constable so-and-so for about 10 to 15 minutes. After Constable so-and-so sent the UTP so-and-so to fetch a bottle of rum from the quarter of Constable G. Dai. Accordingly, so-and-so, that is, brought a quarter of rum from the partner of B and Constable G. Dai and handed over to Constable so-and-so, which was immediately handed over to UTP so-and-so. After a few minutes, again, Constables, that is, Mokenangu sent the UTP bringing another bottle of rum by paying him ₹30, which was given by UTP so-and-so. According, by the time also Constable so-and-so shared the bottle with the UTP so-and-so, and then the three. After consuming the rum, Constable so-and-so locked the judicial cell and went to residence of one Lama, leaving the key of the judicial cell to the UTP so-and-so, and so left the rifle in the guard room where UTP so-and-so was sitting. It is pertinent to mention here that the distance from judicial to Lama residence was nearly half a kilometer, and it took almost half an hour by the duty constable Moken Angu to come back to the judicial cell with full bottle of rum. After arrival of the rum room, which is attached to the judicial custody, constable consumed the entire bottle of rum with 3 UTP. The 3 escaped UTP mentioned above and start to talk with another UTP so-and-so in accused of a murder case by keeping open the main door of the judicial cell attached to the guard room. In that time, all the other UTP were also very busy, were very much available at the corridor existed in between guard room and judicial cell, and witnessed the activities of consuming alcohol by the duty constable along with 3 UTPs. In the process, at about that is 21:59 p.m., the 3 UTP mentioned above came out to the guard room through the open door and pushed back UTP so-and-so to the judicial cell, who was sitting in the guard room, and locked from the outside and went directly to the back of judicial cell building and managed to escape through the site, which was not properly fence guarded by the boundary wall. On inquiry, it revealed that the very date of incident, 10/11 of 2007, neither the guard commander, namely so-and-so, were present in the room from 8 to 9:15 hours when the incident had happened. Lordship, here from the inquiry report also says, at that point of time, Constable Moken Angu was in duty. He was deployed as a constable. Lordship, after this inquiry, there was a memorandum of charge, and I'll just not bother. Lordship, we have given our written submission, that since the judicial custody is not, it cannot accommodate more than one, just one police personnel is there to look after, since that the judicial custody is also not in a proper way, where all the police personnel can stay there. Lordship, and after that, and since there was no proper lordship bathroom and all, there was nothing lordship. So as we have made it in our inquiry, in our written statement, I'm not bordering that lordship, but the fact matter that at the time of when the UTP had escaped, it was the Mokenangu who was in charge of the judicial custody. So when this inquiry report and like after taking this into consideration, DSP Rowing had after a disciplinary proceeding, lordship, a penalty was imposed upon us. Lordship, that I'll just read the page 27 of my petition, lordship, whereby lordship penalty were imposed upon the 5 police personnel and Mr. who was in charge, Mokenangu, was struck. His name was struck off from the service book. I'll take this page 27 of my petition. May I read, lordship? Page 27. In view of the cumulative fact and circumstances, since the lordship, the inquiry report they have
27 of your petition.
of my petition
In item
in
number.
item number 21, lordship. Sir, yes. This is a inquiry report prepared by DSP and it was submitted to the Commandant Aloyon. Here also it says in may I read on that? Just the operative portion. In page 20, paragraph 2nd, lordship. In view of their admitting their guilt, I do not consider proceeding further with the department inquiry as the delinquent have admitted their guilt in writing. That was lordship taken. We have never admitted, since we have written our written statement also at that point of time, we are not since we are there, but it was not our duty, or the roster was, we are not in our roster. In view of the cumulative fact and circumstances as enumerated above, I find that delinquent sanitary Constable M. Angu for committing grave offense of severe neglect of his assigned duty, which facilitated the escape of aforesaid 3 UTP from judicial lockup by his grave misdemeanor and lack of basic responsibility. Here also, lordship, this is lack of M. Angu. Not only he kept the UTP outside the lockup in the guard room, he also had left the BN campus by handing over his service rifle to the UTP along with the key of the judicial cell, thus committing grave misconduct and deliberate negligence of duty unbecoming of a government servant being a member of discipline force. This misconduct on his part rendered him unfit to be retained in police force. I recommend a major penalty for Constable M. Angu for his act of severe negligence of duty and misconduct. The other delinquent, namely so-and-so, that is the petitioner, and so-and-so, are also found to have neglected their duty by abstending themselves from the judicial cell rowing where they were assigned to perform their duty as guard to UTP. I recommend a major penalty to all of them considering their misconduct and deliberate negligence of duty unbecoming of servant or government servant being a member of discipline force, which was rendered them to be retained in the police. This was the inquiry report by the DSP Rowing after the inquiry made by the inspector. Lordship, and that then after there was a departmental inquiry in which lordship this by commandant, that is our headquarters is in Alo, lordship. So that was final. It had made lordship. I'll take to page 31. That is the by disciplinary proceeding. Page 31. That is annexure 3, lordship. May I let you?
Yes.
Coming.
Have you informed this one? Have you informed the standing council, Mr. Vikram? Have you informed Mr. Then what is it? Council only left the court. Just a second, Mr.
Yes.
So he had already left the court.
Yes, I called him up. He said that he has already left. won't be returning now.
Do you have any convenient date for you?
And any date, only 2 things has to be observed here, that they are not filing the legislative opposition since 2 years now. So considering this be the last opportunity, and otherwise next date we can go for the hearing on non-travelers that they are not filing, so the facts are.
Okay, okay, I'll
Only
pass
that
you on.
one.
Okay, sure.
Well, I'm here after that, my announcement take up for just dictation of one.
May I, Lordship? Let's see, page 31, that is the departmental inquiry by whereby we are impose a punishment, Lordship. I'll just go to operative, since the inquiry report also says that, Lordship, on that point of it was Mr. M. Angu, it was his duty, but just because, Lordship, they said it's a personal, like, it's a disciplinary force. It's a, since everyone, we have been also like said, it was our duty also, only just saying that it's a disciplinary. May I read, Lordship? The last second paragraph, Lordship, that therefore, therefore, the undersigned in exercise of power conferred under sub rule clause B of Rule 3 of the APP, that is Arunachal Pradesh Police Department DA Rule 99 Amendment Rule 2005 hereby confer the purpose of penalty of removal from service to Constable Moken Ango. That the one who was in charge, he was removed from the service of second BN headquarter Alo, and his name is struck off from second BN from the date of issue of the order as per rule sub-rule to subclause B Rule 3 of APP Discipline and Appeal Rule 99 Amendment 2005. Also confirm the purpose penalty of reduction to lower stage in the same time scale payment with cumulative effect permanently, that is rupees 3,200 to, that is to Head Constable Wangham Lawang, Constable Lens Naik so and so as their promotion scheme respectively. This was, Lordship, the penalty imposed upon us. And taking, Lordship, since the penalty was, we had made an appeal before to the DIG BN. Lordship, that was also not considered. And Lordship, that was not considered, and Lordship, and like, since it's a disciplinary force, Lordship, we also, after that, we said quite, but
So
Lordship.
except Angu, the others were not discharged or dismissed from the service.
Yes, Lordship.
So there was the penalty that with cumulative effect permanently so and so will be deducted.
Yes.
Anyway. Okay.
Lordship, we have filed a review, since, Lordship, the penalty has been imposed upon all of us. Lordship, we as a disciplinary force also, we also kept certain. But Lordship, irony is that in meanwhile, Lordship, Mr. Angu has filed a review petition that was considered by the higher authority. That is only, Lordship, that is page 36, Lordship. By order 7 March 2010, Lordship, page annex. By this PH. May I, Lordship, to page 36, Lordship, this is the by the order which the main accused, the main culprit, who was for the reason, Lordship, his prayer was, his review was, prayer was allowed by the higher authority. May I read, Lordship? I'll just come, Lordship, I'll not bother much, I'll just come to the operative portion, Lordship, page 37. That which I have annexed as Annexure 5. I have carefully gone through the inquiry report, evidence on record, order of disciplinary authority, as well as appellate authority, and also considered the point raised by the review petitioner in his petition. I also heard the petitioner in orderly room on 8/2/2010 at length. The accused submitted graphic description of the utter penury he is in and admitted his unqualified guilt. Taking an extreme lenient view to the peculiar circumstances, I modify his earlier punishment to reduction of his payment to his initial stage in the time scale of pay and treat his period of suspension and period of absence from the date of removal to the date of joining at second BN APPBN allow as break in service not spent on them. He is reinstated in the service with modified punishment. Lordship, he was re-modified and he was reinstated in his service. And taking this also, Lordship, we have filed a review petition before the concern on the IGP of police, but which is lying, which they have not taken any action against them. Meaning their Lordship, this was in year 2013. They have not considered our prayer.
Where is the review petition?
Page
38.
Page 38, Lordship. Here also we have taken the same prayer, Lordship, since it was not our fault, but it was a fault of M. Angu. Since his review has been considered by the higher authority, we also ought to be considered, Lordship. That is our simple prayer, Lordship, for this honorable. And Lordship, I would like to.
So authority did not consider your prayer, or it is still pending?
Lordship, rejected.
Rejected. You have not annexed that one?
Lordship, at that point of time, it was not considered. Now maybe.
I have an next.
No.
In item number 22.
Oh, no.
22.
Police वाला तो चाहिए.
Item number 21 also, there should be an action.
Lordship,
By filing an additional affidavit also, you can annex the petition, no? The disposal.
Lordship, I'd like to take this honorable court, Lordship, as per the Arunachal Pradesh Police Discipline and Appeal Rule
No,
99.
that will come later on. You have filed your rejected petition in which page?
Is page 52. Page 52 number.
The 7 December 2012.
Yes.
Huh? 7 December 2012.
Yeah. Review
But-
petition.
Huh?
Review petition was rejected, my lord, by this order.
But then why have you have not your petition, you have filed your petition in 2013 only? Why you have not filed your thing, rejection order? Because you have challenged the order of the review committee, na? Okay, anyway.
Lordship, in this one, Lordship, there were 5 Lordship constables in the duty. All have come, 4 of them have been Lordship.
This review was filed by 4 of them.
No, not
All 4, not 3.
4 of them have come to this honorable court, Lordship. Already 2 other 2 case has been already disposed of by this court last week only, Lordship. It's the same case. Now this honorable court, I don't think can pass any other order than this order. I have the order. Last week only it was
Lordship, I'd
passed,
like to
Lordship.
distinguish, but that is all different, it's regarding to different, fate is different.
No, fact is not
Fate-
different. They
it
were
is
not,
also
they
police
were
personnel,
absent
but
in
it
the
is-
duty.
It was pertaining to different police station, Lordship.
No.
Yes,
No, no,
different police station.
Different police station. We are talking of Rohing. That's
Yes,
why the
but then,
honorable-
but then escaping of UTPs.
These were from different police stations.
Yes,
different from police station. Thing has to be Lordship, from each and every pack has to be seen, it's a different, Lordship. And here in the inquiry report also, Lordship, they have stated the roster also they have given. Lordship, since like we have been taken action under the Arunachal Pradesh Police Discipline and Appeal Act. Here also, Lordship, in the subclause 18. May I take, Lordship, at the page 18? If just Lordship. Lordship, afterward, there was an FIR against us, and then there was a criminal proceeding against us before the Rohing police station, before the Rohing CGM Lordship. There also Lordship, we have been, on framing of charges, we have been acquitted by the Honorable Trial Court below, saying there is no case against us. That also Lordship, I'd like to place Lordship. Sir, next case, no, which my elder brother has annexed Lordship in his, it is in his petition number 22 Lordship, page 53 Lordship.
You paid for a discharge and accordingly you have been.
Discipline and appeal.
53. You annexed in page number?
Page 53, my lord. Order at page 53. After that, I have filed review petition.
This is the order of your acquittal, 53. Then page 55.
Yes, my lord. I have filed review petition under Rule 18 of Arunachal Pradesh Police Discipline and Appeal Rule 1999, my lord.
Yes, that is the rule he is referring to.
By that rule only, they have taken punishment penalty against us. And this, what these rules say, Lordship, may I just take Lordship? I'll not bother much in the Rule
And
18.
then 55, we have filed a review again after your acquittal.
Yes, my lord.
Then what is the result again?
Result is at 58, my lord. My review petition was also rejected.
Subsequent review petition was also rejected.
Rejected, finally.
58.
Yes, ma'am.
But you have not filed any.
Lordship, I have not filed.
No. He has already filed 2 review petitions.
Yes, ma'am.
One earlier and then again after acquittal. He has already filed applying the proviso of the 18 of the
yes.
Policeman Well Act. Now thereafter he again filed and again the review was rejected.
Yes.
So have you filed? You have not
I
filed.
have not filed. Lordship.
In item number 21, you have
I have
not
not
filed.
filed. Since in the affidavit, Lordship, they have said the review is still pending.
Also, I have the reports also with me. And then Lordship, I will say it again, but then Lordship, the last 2 which has been disposed last week, Lordship, these were up together for disposal, but then the court could not take up more, Lordship. If you
because of
say who was the judge actually? Who was looking after those 2 petitions? These 2
Justice,
Justice.
you
You can ask. Justice, you can. Just last week, it has been disposed of. Dismissing the petition. More or less, this is the same, Lordship. No, it's
Not
okay,
more
but
or
less, Lordship, it's totally same, Lordship, similar. Maybe from different police station, but the facts are similar. Same. Lordship.
No, my lord.
They
It
were
is from
on the
different
duty.
police station.
No, police station is different.
Maybe,
He is
but
saying the
escaping of
otherwise
UTP.
facts is
Yes.
similar, the escaping of the UTPs from the lockup or what.
Yes, Lordship. Departmental inquiry, everything was taken up.
maybe on, but I'll not, since I have no, what, Lordship, here we have to see the inquiry report themselves says that there was a roster. where the police personnel were deployed from one to.
Okay, there was
That's- Your
roster
Honor,
and you two are the home guard or key guard,
Commander.
commander guard. So do you say that
Constant.
the responsibility was not casted on you also? Because you are the persons who
Yes.
allotted the duties of so and so.
Yes.
So in that case.
was not there.
We cannot be around 24 inches. And Lordship, I'm not going to that. Lordship,
No,
Lordship, I'm not saying, no, no, what,
differently.
Lordship, what I'm saying is they have taken action against, under me, against the rule on the Arunachal Pradesh Police Discipline and Appeal Act Rule 2019. Lordship, I'm not saying what the Rule 18 says there, Lordship. May I take your Lordship? That's what, because this also has to be, this is their own rule book, Lordship. I'm not saying, Lordship,
Okay, then
18
what
says,
18 says?
18, action following judicial acquittal.
Yes.
It says when a police, may I read, when a police official tried and acquitted by a criminal court, he shall not be punished departmentally on the same charge or on a different charge upon the evidence cited in the criminal case, whether actually late or not unless late. Since Lordship here, our competent court has acquitted us on consideration of charge, on a charge. The criminal charge has failed on technical ground or in the opinion of the court or the superintendent of police, the prosecution witness have won over. Subclause 3, the court has held in its judgment that there was no judgment. The evidence cited in the criminal case disclosed fact unconnected to charge before the court which justified department proceeding on different charges. Additional evidence of department proceeding is available. Your Honor, Lordship, I would like
Under which section your case was registered against you, the criminal cases?
section 223, Lord, or 3 or 2 to 20, 2 to 3.
2 to 3. Okay.
Lordship, my prayer before this honorable court, since the main accused person in whose presence all the thing has happened, his review petition has been considered by the higher authority. And Lordship, the police personnel act and appeals in Rule 18 says when a competent court has discharged, acquitted. So I cannot be taken, disciplinary proceeding cannot take place before me. That's all, my Lordship. And this is a fit case, Lordship.
Yes. Any other submission?
Also, is about the loss of the criminal case lawsuit. This is with regard to the criminal charges lawsuit. This is with regard to the departmental inquiry lawsuit for disciplinary. The petitioners are in disciplinary force lawsuit. They ought to have acted more responsibly lawsuit because of their negligence lawsuit. The UTP and the trial prisoners, they have escaped lawsuit. At that point of time when the prisoners escaped, none of them were there in the lawsuit, duty lawsuit. Everyone is saying, giving their own excuses lawsuit. But the fact is that remains that they were not there lawsuit. Lawsuit. And so far as the petitioners are comparing to that other who was lordship removed from the lordship service lordship. That file penury lordship, they were no one was there. He was the only working person from the family. Keeping that in this one, his case has been considered lordship. And as per their lordship, the punishment is not that proportionate lordship to their action lordship, what they have done lordship. Is 1 year increment with lordship, cumulative effect, with cumulative effect, that much only lordship.
But otherwise he was removed from service. The other one whose application review was,
yeah.
yes.
Yes. He was removed otherwise. And then lordship, In the similar situated case, this one, the other one, other two cases, already the petition has been dismissed also. So, Lordship, may I- And Lordship, the record is with us, Lordship. I can give it to the Lordship.
Yes, what I've said.
It's not a case that Lordship departmental inquiry, they were not given chances. Every chance was given to them, every opportunity was given. They were heard properly and then only this Lordship impugn order was passed.
What do you want to say in regards to clause 18 of the Arunachal Pradesh Police Disciplinary? As per their submission, as he has been already acquitted by a criminal court or a competent court. So that is in. But otherwise, do you think that the criminal proceeding different?
Is different, Lordship. That is against criminal charges, Lordship. This is departmental inquiry, Lordship. As per disciplinary action, Lordship, they can be, Lordship.
Lordship, in Rule
Says so,
18, it
Lordship.
says clearly, it shall not be punished departmentally on the same charge. I don't know, how would you interpret? It says that punished departmentally on the same charge or on different charge upon the evidence cited. It says, Lordship, clearly the Rule 18 says, if the personnel is accused from the criminal court, he shall not be punished. And even there was no trial on the framing of charges itself, Lordship. The trial court finding that there was no any negligence on the part of the petitioner, the other accused person. It has honorably acquitted all of them, discharge them, not acquitted, even discharge them, Lordship.
Reserve for it. Reserve for it. Give this one. Also. Okay, pass your.
Lots of records.
Oh, the records are there, no?
Yes, Lordship. This can be taken.
Records. Can you keep it with you now? Otherwise, records in the sense, what do you want to show from the records mainly?
Lots of inquiries, everything was done.
Enquiry, as per them also, enquiry report was there.
Yes.
And it is admitted fact that they admitted their guilt also before the authority
Yes,
concerned. That is not disputed, I think. But only thing is that they were not there at the time of relevant incident, and it was under the charge of Mr. Angor or whatever. That is their main allegation. So, a record.
Not with that's
If
necessary.
not necessary, then I will not.
Lordship, we have given our written statement reply to the disciplinary comment that we have never accepted the guilt. We have only said that Lordship those on roster
You have
basis.
not accepted the guilt, but the enquiry
Yes,
report
yes.
done by the investigating officer as well as by the departmental authority, it was found that that
Yes,
was
we are
your
not present
negligence
at
or
that
what.
point. We are not disputing.
Okay, then at this stage I don't need to require.
Yes, sir.
If for any further clarification if requires, I'll just inform you. I'll just inform. I think it was 600. Okay.
Bibliography.
The date may be fixed.
These two has already heard, they've already heard. Huh. Only this one left. Is it interested to do this one? Or if not, then we pass over it. I just ask them. Yes, what do you want to say?
Lordship, only that the date may be fixed. And since that they have not filed their affidavit in opposition since 2 years, this date may be the last opportunity for them to file it. Or else they'll forfeit their right of filing an affidavit.
So what the
I'm for the
affidavit filed?
No, Lordship. Those are affidavits filed by me only because of the private respondents not participating.
It's a petition.
So yes, the court has asked us to do paper publications and Dusty service. Those are Dusty and paper publications.
Okay.
affidavits.
But is it no note in the office note of the registry? In regards to the as to whether they have filed or not? It's not.
Lordship will
mentioned.
find the first order on 2/6/2022. That was the order passed by Justice Arundev Chaudhary, sir. In that, they have said the affidavit needs to be filed by respondent 1, 2, and 3, the RPWD department, Rural Public Works Department.
2/6? Dated 2/6?
2/6/2022. Here the respondent 1, 2, and 3 have to file their affidavit. But until date, no affidavit has been filed.
Item number 6. Mr. Your name is not here?
Jay Singh. My name is not reflected, but I have my wakalatnama
Yes,
filed.
yes.
With
Okay.
full counsel.
You're Mr. J. Singh.
Jay Singh, Lordship.
J. Singh. Heard Mr. J. Singh for the petition. Learned counsel for the petition and the standing counsel, Mr. G. Tarak, is found absent when the case was called for. Full stop. It is submitted by Mr. Singh that the respondent number 1, 2, and 3 were given were directed to file their affidavit in opposition, if any, by the order dated 2/6/2022 by this court. But even after a lapse of 2 years, the respondent has not filed their affidavit in opposition. But why service was awaited for 4 and 5?
For 4 and 5. They are the private respondents. They have declined to take the copies. So court has directed paper publication. So all this process took some while.
Submitted written affidavit in opposition even after lapse of 2 years, and accordingly it is submitted that the matter may be heard or matter may be heard in the absence of any affidavit in opposition, if and accordingly submitted that respondents seems to be not interested to file their affidavit in opposition, and matter may be heard accordingly. Next paragraph, considering the submission of the learned counsel for the petitioner, where the state respondent number 1, 2, and 3 is hereby given one more chance to file their affidavit in opposition, if any. In default, the matter may be heard and decided accordingly, even in absence of the affidavit in opposition. List the matter accordingly after 3 weeks.
After vacation, my lords. After vacations.
After vacation.
17 or 18, any date, my lords.
Want any fixed date?
It would be convenient.
Want any fixed date?
It would be convenient for me.
List the matter accordingly on July 17th, 17th of July. Okay.
17, it's marked blue. It might be some holiday.
For
Restricted
Arunachal, it's not
holidays.
holiday.
Okay, okay.
17th of July, you are saying?
17th of July.
17th July is not marked. It's holiday. It's not open.
Obliged.
17th June is a holiday. Maybe.
17th June. Obliged.
Please, Lordship.
What to say?
Lordship, can it be tomorrow? Lordship, here.
Tomorrow, so I cannot say because tomorrow list is already ready, I think. So tomorrow,
Subject to the. Okay.
Wednesday.
Can it be on day after?
On Thursday.
Thursday.
Thursday list is not yet ready, na? Thursday? Ready
Matter-
হৈছে নেকি? নাই হোৱা?
My
Can
lord,
we-
the
yes.
matter is of 2018, of course.
Yes,
But-
yes.
But in my lord, here our affidavit will be required, my lord. And I have a communication with the department and for the department, then department, my lord. As per my instruction, they have already prepared the affidavit and that has been now sent to Globe, Betul. It will only take 1 to 2 weeks, my lord.
They will give it, this one is the matter. This is the matter? Because it is, see, it is it is of 2018 matter.
18
Yes,
matters.
my lord.
So-
It's
That-
been,
that is
lordship,
okay.
already 7 years had been passed. They have
Mm.
not filed their affidavit. And today, at this last moment, lordship, they are coming and saying that they want to file affidavit.
That is why, my lord, I have spoken to my secretary yesterday. And I was told that affidavit is ready, only it has been now sent for law writing. It is in the table of law department. So it will take hardly 2 weeks, my lord. It is always better, my lord, if all the pleadings are exchanged and get the matter disposed of.
But for exchanging of pleadings, you took 7,
That is true,
6,
madam.
7,
Yes,
8.
that
Yes,
is true,
lord.
madam.
7 years. And in, if I'm not wrong, there is a order whereby the council has declined to file affidavit and they have made a submission that they will rely on the affidavit filed by the respondent number 5. It is also there.
Oh,
That, my lord, I am admitting, my lord. Right. Admitting that, my lord, in our-
so you are representing the respondent number? Who are?
My lord, then department secretary and director, my lord.
The respondent numbers?
1,
2, 3, 4.
2, and 3, my lord. And 4, and 4. 1, 2, 3, and 4.
Director.
1, 2, 3, and 4. 5, you are 5.
Yes, your lordship.
5 had already filed.
Yes, your lordship.
5
We have
have
already
already
filed.
filed. And 6 and 7, their private respondent, they didn't turn up despite of serving notice through the dusty. In that regard, we have already filed affidavit regarding their receipt of notice through the dusty service. And paper publication was also done in respect of respondent number lordship 7, but they intentionally declined to contest the case.
If my lord, is of the view that since it's been more than 5 years. And
7 years.
7 years.
And during this period, if the department has not filed the affidavit, and if my lord is of the opinion that department should not be allowed any further time for filing affidavit, then my lord, my submission may be this recorded.
No, you have just submitted now, you have
Yes.
submitted that the affidavit in opposition is almost ready in a ready, it is in the
Yes,
table
yes,
of the
yes, my lord.
law department.
Yes, my.
So only needs some formalities to
Yes, ma'am.
place
Yes,
before us.
Yes, ma'am.
So if that be the position, let us see 1 week or say 10 days time may be given.
My lord, again, if suppose since all the state machineries, they are involved in this election.
Then you need 2 weeks.
Yeah, 2 weeks, madam.
But otherwise, there was an observation that they are not going to file.
Yes, they will relay the statement affidavit of the private respondent number 5.
Pardon, Mr. Anderton, the Land Council. You are Mr. N.
K. Lolan.
K. Lolan, sorry. Heard Mr. K. Lolan, the Land Council for the petition. And also heard T. Tambo, the Learned Council appearing on behalf of respondent number 1, 2, 3, and 4.
Yes, ma'am.
1, 2, 3, and 4, and heard MS
P. Pangu, your lordship.
P. Pangu, the council, the comment advocate.
Yes, your lordship.
Comment advocate appearing on behalf of the respondent number 5. The respondent number, you have already, is there any order in regards to respondent number 6 and 7?
It might be because I have already
Taken steps.
Yeah.
Then it is already in the hearing. call.
Yes, yes.
Okay.
Affidavit regarding dusty
The
service.
matter
is
is
also-
listed for hearing today, but it is submitted by Mr. So-and-so, the Learned Standing Council for the Then for respondent number 1, 2, 3, and 4, the Land Management Department, that the affidavit in opposition is ready and which is lying in the law department, but could not file it due to as some formalities yet to be observed, and accordingly it is submitted that 2 weeks time may be given for filing the affidavit in opposition by respondent number 1, 2, 3, and 4. Full stop. In this context, the learned counsel for the petitioner has submitted that in earlier occasion, it was the plea of respondent number 1 to 4 that they will rely on the affidavit in opposition, filed by the respondent number 5. Full stop. Further, he submitted that case is pending since 2018 and hence no more the respondent number 1, 2, and 3, and 4 may not be given any more chance to file their affidavit in opposition. Full stop. Next paragraph. Considering the entire submission made by the learned counsel for both sides and the other circumstances of this case, the respondent number 1 to 4 is hereby directed to file their affidavit in opposition within 2 weeks from the date of order. In default, the matter may be heard accordingly. So it will be last chance, 2 weeks time have been given, and otherwise it will be heard in the same
Yes,
week.
in that case, Lordship, may I humbly pray that specific date of 2 weeks may be mentioned to file the affidavit, Lordship, from today.
Okay, we did 2
ask
weeks. 2 weeks will be.
Get the best.
Which month?
May I?
18.
June 4.
18/6.
Yes.
On within 18/6,
18.
2024. List the matter accordingly after 2 weeks.
List and Lordship and Lordship matter may be listed on 20.
You
They will
want any
file
fixed
their
date? What fixed date?
yes on
Oh.
20.
By 18 they will file,
They
and
will
by
file
20 it will be
and
listed.
Lordship direction may be issued to them to furnish me a copy on 18th.
That it will be
Because
furnished, I think.
and matter may be listed on 24 hearing.
By 18/6, on or before 18/6, you file your affidavit in opposition. Copy be served accordingly and matter may be listed on 26.
Deeply obliged.
Oh.
And Lordship here,
Is there any submission? Yes.
Lordship, on last occasion, the counsel for the respondent 5 was directed to obtain instruction regarding the current status, allotment status of private respondent 6 and 7. I think she might have received.
Yes, Lordship. We have already received, Your Lordship.
Received the instruction.
Yes, Your Lordship.
That may be placed on
That
record.
that may be, no. Already you received the instructions from
Yes.
your department.
Yes, Your Lordship.
Yes, so the MS so-and-so, the learned government advocate further submitted that they have already received the instructions from the department
Yes.
in regards to the respondent number 6 and 7.
6 and 7. Land status or allotment status of
Allotment status of respondent number